Your property is in violation. You have 14 days to comply, or we will take action. She said it the way people say things they have rehearsed, flat, certain, carrying the practiced weight of institutional authority. She was standing at the edge of what had been, 24 hours earlier, a perfectly level grass airstrip, and she was holding a clipboard, the way a person holds a weapon they have never actually fired. The asphalt was still warm. I could smell it from where I stood. That particular petroleum heat that clings to the back of the throat, the smell of something permanent being done without permission. I looked at the clipboard. I looked at the fresh black surface where the grass had been. Then I looked at her. She had no idea. No idea that the strip of land she was standing on, the access road her crew had driven in on, the staging area where her contractor had parked his equipment, all of it sat on a parcel I had owned outright since the day my grandfather's estate was settled 41 years ago. I held the deed. I had always held the deed. I had simply never needed to say so out loud. Drop a comment. Tell me where you're from. And if something like this has ever happened to you, I want to hear it. My name is Calvin Merritt. I am 63 years old, and I have been a licensed pilot for 38 of those years. The land you are about to hear me describe is not a subdivision lot. It is 214 acres of high desert plateau in the eastern reaches of a county that most people cannot find on a map without help, and it has been in my family since my grandfather, Elias Merritt, homesteaded it in 1931. Elias came west from Oklahoma with a team of mules, a surveyor's transit, and a stubbornness the family still talks about at the dinner table. He broke the ground by hand the first 2 seasons. By the time my father, Robert Merritt, was born in 1938, there was a house, a well, a working windmill, and a set of cedar fence posts along the northern boundary, weathered gray now, but solid, the way things are solid when built by someone who does not expect anyone else to fix them. My father added a hay barn and a stock pond. I added the airstrip. I built it in 1997. I was 40 years old. I had been flying for 15 years, and I had grown tired of driving 2 hours each way to the nearest general aviation airport every time I needed to move equipment or get somewhere quickly. The plateau gave me a natural grade, almost perfectly flat, oriented northeast to southwest to catch the prevailing wind. I cleared the mesquite myself, hired a grader to level the surface, and laid 3,200 feet of compacted caliche topped with a stabilized turf surface that drained well and held up through freeze and thaw. I registered it with the FAA as a private-use landing facility, filed the appropriate paperwork with the county, and marked it on the sectional charts under the identifier 7TX4. It was not a commercial operation. It was a working tool on a working ranch, the same as the stock tank or the equipment shed. I used it to fly in veterinarians when cattle were sick, to receive parts shipments, and once in the winter of 2009, to fly my neighbor Earl Dunbar's wife to a trauma center in Lubbock when the roads were iced over and she had stopped breathing in her kitchen. The airstrip was not a luxury, it was infrastructure. The deed to the parcel, all 214 acres, including the airstrip, the staging area, and the access road, had been recorded at the county courthouse in 1983 when my grandfather's estate cleared probate. Instrument number 1983-00441, Book 47, page 212, Ridgecrest County Deed Records. I had a certified copy in the top drawer of my filing cabinet, inside a manila folder labeled simply Merritt Ranch, and I had not looked at it in years because I had not needed to. The land was mine. The record said so. That was the end of the question as far as I understood it. The trouble began, as it so often does, with a letter. The Ridgecrest Plateau Homeowners Association had been incorporated in 2014 when a developer named Castillo built 47 single-family homes on a 380-acre tract bordering my eastern fence line. The development was called Mesa Pines, which struck me as optimistic given that the nearest pine tree was approximately 90 miles north, but I did not say so. The HOA's CC&Rs were clear. They applied to the lots within the Mesa Pines subdivision plat, nothing more. My land was not within that plat. It never had been. The plat boundary ran along my eastern fence line, not across it. For the first 4 years, this was not a problem. The HOA managed its 47 lots. I managed my 214 acres, and we coexisted in the way neighbors coexist when they have nothing particular to say to each other. The access road crossing the southern edge of my property was a county-recorded easement predating the subdivision by 40 years. It gave the county and adjacent landowners ingress and egress across a strip 20 feet wide, and Castillo's development had used it as their primary entrance because it was the most practical route. The easement was recorded. The use was lawful. There was nothing to argue about. Then, in the spring of 2019, the HOA elected a new board president. Her name was Diane Colworth, and she arrived at the position the way certain people arrive at minor authority, with tremendous energy, a detailed vision, and a fundamental misunderstanding of where her authority actually ended. She drove a white SUV with the Mesa Pines HOA logo on the door. She wore blazers in the desert heat. She carried a tablet and a clipboard simultaneously, which I have always found to be a particular kind of statement. Within 60 days of her election, she had launched a beautification initiative, proposed a gate at the subdivision entrance, and sent her first certified letter to my address. The letter was dated April 14th, 2019. It cited Section 4.2 of the Mesa Pines CC&Rs, which governed landscaping standards and aesthetic compliance within the community. It informed me that my property on the other side of the fence line, was creating what the letter called a visual disruption to community standards, specifically referencing the airstrip and the windsock I had mounted on a 12-foot pole near the approach end. The letter requested that I remove the windsock, cease aviation-related activity during community quiet hours, and submit to an HOA property inspection within 30 days. It carried a fine schedule, $200 for initial non-compliance, escalating to $500 per month thereafter. I read the letter twice. I set it on the kitchen table next to my coffee cup. I looked out the window at the airstrip, quiet and level and exactly where it had always been, and I thought about Section 4.2, which I had read 4 years earlier and which applied to lots within the subdivision plat, not to adjacent private property. I thought about the fence line. I thought about the deed in the filing cabinet. Then I got up, refilled my coffee, and called my attorney. His name was Gerald Foss, and he had been practicing real estate and property law in Ridgecrest County for 31 years. He was not a dramatic man. He spoke in complete sentences, billed by the hour, and had the quality of a person who has read a great many documents and is therefore very difficult to surprise. I drove into town the following morning and put the letter on his desk. He read it without expression. When he finished, he looked at me over his reading glasses. "She's citing a covenant that doesn't apply to your parcel," he said. "That's what I thought," I said. "Your land isn't in the plat." "No." He picked up the letter and looked at the fine schedule. $200, he said, in the tone of a man reading a word he finds mildly interesting. He set it down. "I'll send a response. Standard letter, certified mail, citing the plat boundary and the recorded deed. That should be the end of it." It was not the end of it. Gerald's letter went out on April 29, 2019. It cited Instrument 1983-00441, the recorded plat boundary, and the specific limiting language of Section 1.1 of the CC&Rs, which defined the association's jurisdiction as the lots depicted on the recorded subdivision plat of Mesa Pines. It informed Ms. Colworth that my property was not subject to the association's covenants, that the fine was without legal basis, and that any further enforcement attempts would be considered a legal nullity. Diane Colworth sent a second letter 11 days later. This one cited an amendment to the CC&Rs that the board had passed in February of 2019, 2 months before her first letter to me, which purported to extend the association's aesthetic and compliance jurisdiction to properties within 500 feet of the subdivision boundary. I read that sentence 3 times. Then I called Gerald. "Can they do that?" I asked. There was a pause. "No," he said. "An HOA cannot unilaterally extend its jurisdiction to property it doesn't own, and that was never subject to its covenants. That's not how any of this works." Another pause. but she apparently believes otherwise. She sent a crew out last week, I said. Walked the perimeter of the airstrip with a measuring tape. Did they come onto your land? They stayed on the access road easement, barely. All right, Gerald said. Let me pull the amendment, and let's get a current survey ordered. I want a fresh boundary confirmation on record before this goes any further. I hired Tanner Land, surveying out of Abilene. The crew spent 2 full days running the boundary and produced a sealed survey confirming every line exactly as recorded in 1983. The airstrip sat entirely within my parcel. The access road easement was 20 feet wide, exactly as recorded, and granted no rights of inspection, regulation, or aesthetic authority to anyone. The survey cost me $3,400. I considered it money well spent. Gerald filed a certified copy with the county clerk on June 9, 2019. Diane Colworth's response arrived in early July. Not a letter this time, but a formal notice of HOA enforcement action on letterhead bearing a seal I had never seen before. It informed me that the board had voted to engage a contractor to bring my property into compliance, beginning with removal of what the notice called the non-conforming aviation infrastructure along the eastern boundary of the affected zone. It was signed by all 5 board members, and it included a line I read with the particular attention I reserve for things that seem impossible. The board has determined that the access easement provides sufficient legal authority to conduct maintenance and compliance activities on adjacent parcels within the affected zone. I set the notice on the kitchen table next to Gerald's survey and looked at them side by side. The survey was a sealed legal document filed with the county, reflecting 41 years of recorded ownership. The notice was a piece of paper produced by 5 people who had apparently decided that a 20-foot access easement gave them the right to pave over someone else's airstrip. I was not angry. I want to be clear about that. I was something quieter than angry. The kind of still that comes when you realize the other party has made a decision that will cost them considerably more than it costs you, and that the only thing left is to let the record catch up to them. I called Gerald that afternoon and told him to file for a temporary restraining order. The TRO application was filed on July 22, 2019, in the 142nd District Court of Ridgecrest County. It cited the recorded deed, the fresh survey, the limiting language of the original CC&Rs, the legal nullity of the February 2019 amendment as applied to non-member property, and the specific text of the access easement, which granted ingress and egress only and contained no language authorizing maintenance, improvement, or compliance activities of any kind. Gerald attached certified copies of every document and built the file the way you build a fence, 1 post at a time, each one set deep enough that it does not move. The court granted the TRO on July 24th. It prohibited the HOA, its board, its agents, and its contractors from entering my property or conducting any activity on my land pending a full hearing. The order was served on Diane Colworth by the Ridgecrest County Sheriff's Office on the morning of July 25th. I was told she received it in the parking lot of the Mesa Pines Community Hall, beside her white SUV, and that she read it twice before folding it and going inside without a word to the deputy. I went out that afternoon and walked the airstrip from one end to the other. The turf was dry and firm under my boots. The windsock moved in a light southwest breeze. Everything was exactly as it had always been. The TRO bought time, but it did not buy peace. The weeks before the September hearing were quiet on my land, but not quiet in the broader sense. And I learned most of what was happening through Earl Dunbar, who lived a half-mile east of my fence line with his property abutting the Mesa Pines development on its northern edge. Earl was 71 that summer, a retired diesel mechanic who had spent 40 years rebuilding equipment in conditions that would have broken younger men, and he had the quality of a person who pays attention to things that do not announce themselves. He drove into my yard one morning in early August in his old green pickup, the one with the cracked passenger mirror he had never gotten around to replacing, and sat across from me at the kitchen table and told me what he had been hearing at the feed store and the diner and the county extension office. "She's been telling people the TRO is temporary," Earl said, "saying the court will side with the association when it hears the full case, saying your airstrip is a nuisance and a safety hazard." "She's entitled to her opinion," I said. She's also been talking to the county, Earl said. He set his cup down. Someone filed a complaint with the county zoning office, claimed the airstrip was operating commercially. It's registered with the FAA as private use, has been since 1997. I know that, Earl said. I'm telling you what she filed. Gerald already knew. The complaint alleged that 7TX4 was being used for commercial aviation purposes in violation of the county's zoning ordinance. It cited as evidence that aircraft other than my own had landed at the strip on multiple occasions. This was true. It was also entirely lawful. I had hosted 3 other pilots over the years, friends, a veterinarian who flew his own Cessna, and once a crop duster who had declared a fuel emergency. None of that constituted commercial activity. Gerald pulled my FAA registration records, my fuel logs, and the county's own definition of commercial aviation use, which required compensation, hire, or the carrying of passengers or cargo for remuneration. There was none of that in my records. Gerald responded on August 19th, citing the FAA registration, the private use designation, the county's own ordinance definition, and the absence of any evidence of commercial activity. He noted that the complaint had been filed anonymously and that the strip had operated lawfully since 1997, without a single prior complaint. The county zoning office closed the matter without action on August 28th. I placed the 1-paragraph closure letter in the manila folder alongside everything else. The folder was getting thick. What I did not know until Gerald pulled the full file for the September hearing was that the February 2019 amendment had not been properly passed. The CC&Rs required a 2/3 majority of all association members to amend the foundational governance documents. A 2/3 majority of 47 lots was not 5 board members voting among themselves on a February evening. It was 32 homeowners voting in a properly noticed meeting with a quorum present and ballots recorded. Gerald had requested the meeting minutes through a formal discovery request. What came back after 2 weeks and a motion to compel was a set of minutes showing 5 board members present, 5 votes cast, and no record of any membership meeting, any notice to homeowners, or any ballot of the general membership. The amendment had not been passed. It had been declared passed, which is a different thing entirely, and the difference tends to matter a great deal in a courtroom. I sat at the kitchen table the evening Gerald called me with that and looked out at the darkening plateau. The stars were beginning to show in the east. I thought about my grandfather Elias, who had sat at a table not far from this one and made decisions about land by the same light. He had understood something I had come to understand by a different route, that the record is the thing, not the argument, not the authority, not the confidence of the person making the claim. The record. What is written down, filed, sealed, and preserved against the day when someone needs to know the truth. Gerald filed a supplemental brief on September 3rd incorporating the discovery findings. It cited Section 209.0041 of the Texas Property Code, which governs the process for amending a dedicatory instrument and requires that amendments affecting member rights be approved by the membership in accordance with the procedures set out in the governing documents themselves. The Mesa Pines CC&Rs required a 2/3 membership vote. The board had not conducted one. The amendment was, as Gerald's brief put it, void ab initio, void from its inception, as though it had never been adopted at all. That was the turn, not dramatic, just a legal phrase in a supplemental brief, attached to a stack of documents that had been building since April, each one placed carefully on top of the last the way you stack fieldstone, not for speed, but for permanence. Earl came by the evening before the hearing. He sat on the porch with me while the sun went down behind the western ridge and the plateau cooled in the way it does in early September, when the nights begin to carry a hint of the season coming. He did not say much. "You think it holds?" he asked after a while. "The record holds," I said. "It always held. We're just going to the place where someone with authority reads it out loud." He looked out at the airstrip, at the windsock hanging still in the evening calm. "Your grandfather would have found this whole business very strange," he said. "He would have found it straightforward," I said. "He would have gone to the courthouse on day one." Earl smiled at that, just slightly, and we sat there until the stars came out. The hearing was held on September 9, 2019, in the 142nd District Court of Ridgecrest County before the Honorable District Judge Patricia Ames. The courtroom was small in the way that rural county courtrooms are small. Wood paneling, fluorescent lighting, the smell of old paper and floor wax, the particular acoustics of a room where serious things have been said for a long time. Diane Colworth was present with the HOA's attorney, a man named Prewitt from a firm in Midland who had been retained only 10 days before the hearing. Gerald had been on this case for 5 months. The preparation difference was visible in the way the two tables looked, ours organized, indexed, tabbed, theirs with a thinner stack and a quality of improvisation I recognized from people who had not done their homework. Judge Ames ran a precise courtroom. She asked questions and expected answers anchored in the record. Gerald presented the deed, the survey, the plat boundary, the original CC and Rs with their limiting language, and the discovery findings regarding the February amendment. He quoted Section 1.1 of the CC and Rs verbatim. The association's jurisdiction shall extend to and be limited to the lots depicted on the recorded subdivision plat of Mesa Pines, as filed in the Ridgecrest County Plat Records at Cabinet A, Slide 114. He quoted Section 209.0041 of the Texas Property Code. He presented the absence of the meeting minutes that would have been required for a valid amendment. He did this in order, without dramatics, the way a person presents a record that speaks for itself. Prewitt argued that the board had acted within its authority to protect community standards, and that the 500-foot provision was a reasonable extension of the HOA's governance role. Judge Ames asked him to identify the legal authority for an HOA to extend its jurisdiction to non-member property without the owner's consent. He cited a case from a different jurisdiction involving a different legal question. She asked him to read Section 1.1 of the CC and Rs aloud. He did. She asked whether my parcel appeared on the subdivision plat at Cabinet A, Slide 114. He said it did not. She asked how the association's jurisdiction extended to a parcel not depicted on that plat. He said the February amendment addressed that. She asked him to produce evidence of the membership vote required by the CC and Rs to enact that amendment. He produced the board minutes showing 5 votes. She asked where the membership ballot was. There was a pause that lasted long enough to be its own kind of answer. Judge Ames granted a permanent injunction that afternoon. The order was 14 pages. It found that my parcel was not subject to the Mesa Pines CC and Rs, that the February 2019 amendment was void for failure to comply with the amendment procedures required by both the CC and Rs and the Texas Property Code, that the HOA's enforcement actions were without legal basis, and that the access easement granted ingress and egress only, conferring no right of inspection, compliance enforcement, or physical alteration of any kind. The injunction permanently prohibited the HOA, its board, its agents, and its successors from asserting jurisdiction over my parcel or interfering with my use of it. It also awarded attorneys' fees under Section 37.009 of the Texas Civil Practice and Remedies Code in the amount of $14,200, which was, to the dollar, what Gerald had billed me for 5 months of careful work. The HOA paid within 60 days. I did not feel triumphant when I read the order. What I felt was something closer to the feeling you get when a long calculation finally resolves. Not surprise, because the arithmetic had always been there, but a settled recognition that the numbers had come out the way they were always going to come out. The record had been correct since 1983. Everything since April of 2019 was simply the process of getting the record read in the right room by the right person. I drove home past the eastern fence line with its cedar posts, past the stock pond my father built, past the equipment shed where my grandfather's old Transit still sits on a shelf because I have never been able to bring myself to throw it away. I pulled into the yard and stood for a moment in the afternoon light. The airstrip was quiet. The windsock moved in a small, easy circle. Everything was exactly as it had always been, and the record now said so in 14 pages, signed by a district court judge and filed permanently in the court records of Ridgecrest County. I went inside and made coffee. What I did not understand in the weeks after the September hearing was that Diane Colworth had not finished. I should have anticipated it. I had watched her operate for 5 months and observed that she was not a person who revised her understanding when evidence contradicted it. She was a person who looked for a different angle. The injunction prohibited her from asserting jurisdiction over my parcel. It did not prohibit her from working through other channels. Earl brought me the first indication in late October, 6 weeks after the hearing. He sat at the kitchen table and told me that Diane Colworth had appeared before the county commissioner at a public meeting and argued that the private airstrip constituted a public safety hazard, that the county had an obligation to act where the court had declined to, and that the board had a legal obligation to the community. She had presented photographs and a document she described as a noise impact study, though Earl said it looked to him like a printed spreadsheet with some numbers on it. Gerald pulled the relevant statutes. The county's nuisance abatement authority under Chapter 342 of the Texas Local Government Code applied to conditions constituting a danger to public health or safety, structures in disrepair, hazardous waste, that sort of thing. A registered, FAA-compliant private airstrip operating exactly as it had for 22 years without incident did not meet that standard. Gerald said so in a letter to the Commissioner's office dated November 4, 2019, attaching the FAA registration, the county zoning records, and the September 9th injunction. The Commissioner's office declined to act. The airstrip was not a nuisance. The record said so. I went through the winter of 2019 and into 2020 with the reasonable expectation that Diane Colworth had exhausted her angles. I flew my Cessna 182 in and out of 7 TX4 on the schedule I had always kept. I hauled cattle. I maintained the fence line. I replaced 3 cedar posts on the northern boundary that had finally given way after decades of service, setting the new ones in concrete the way my grandfather had set the originals. Deep, plumb, and with the expectation that they would outlast the person installing them. In the spring of 2020, the Mesa Pines HOA held its annual election. Diane Colworth was re-elected president. I noted it. I did not dwell on it. The injunction remained in place regardless of who held the board's presidency, and the injunction was what mattered. What happened next did not happen through the HOA. That detail matters to the sequence of events and to the question of responsibility that would eventually be settled in a different courtroom. What happened next happened through a contractor. His name was Brent Aldridge, and he operated a paving and site preparation company 40 miles south of Ridgecrest County. He had paved the Mesa Pines subdivision roads in 2014. In the late summer of 2020, he was engaged by the HOA board to perform what the board's resolution described as access road maintenance and surface improvement along the recorded easement corridor on the southern boundary of the Mesa Pines development. That was the language in the board resolution, which I would obtain later through discovery. The resolution did not mention my property. It did not mention the airstrip. It cited the recorded easement, which the September 2019 injunction had already found granted ingress and egress only. I was not home when Aldridge's crew arrived. I had flown to Lubbock to pick up a hydraulic pump for the tractor, and I had left the ranch with my regular hand, Thomas, who had worked for me for 11 years and knew the property as well as anyone alive. Thomas called me at 11:40 in the morning. A crew of 6 men had come in on the access road with 2 paving machines and a dump truck loaded with asphalt, and they had turned off the easement corridor and onto the approach end of the airstrip before he could reach them. They had been working approximately 40 minutes by the time he got to them on the four-wheeler. The northeast end of the airstrip, approximately 600 feet of compacted turf surface, was already under a 2-inch layer of hot asphalt. I sat in a parking lot in Lubbock for a moment I will not try to quantify. I was not angry. I want to be clear about that. What I felt was something colder and more focused. The recognition that the other party had just made the most consequential mistake of the entire proceeding, and that the record was about to reflect it in terms that would be very difficult to undo. I told Thomas to document everything: photographs, video, timestamps. Do not interfere with the crew physically. Call the Ridgecrest County Sheriff's Office and report a violation of a standing district court injunction. Then call Gerald Foss. The crew was stopped by sheriff's deputies before they reached the midpoint of the strip, but the damage was done. 620 feet of airstrip surface, I measured it myself the following morning with a surveyor's tape, had been covered with asphalt. The turf beneath it was destroyed. The compacted caliche base, which had taken a grader and 3 weeks of curing to establish in 1997, was sealed under 2 inches of petroleum product that had already hardened in the afternoon heat. I stood at the northeast threshold the next morning and pressed the toe of my boot against the edge where the asphalt met the remaining turf. The boundary was clean and absolute. On one side, the surface I had built. On the other, something I had not built and had not authorized and could not use. The airstrip was not entirely gone, but it was shortened, and a shortened airstrip is not a safe airstrip, not for the aircraft I flew, and not for the aircraft that had used 7TX4 over 23 years as the only aviation infrastructure within 40 miles. I filed an amended FAA notification that week, updating the strip's usable length from 3,200 feet to 2,580 feet and flagging the surface obstruction at the northeast end. The strip remained technically open, but a strip with an asphalt obstruction at one end and compacted turf at the other could not be reliably used in an emergency by a pilot who did not know its exact current condition. Not in low visibility, not at night. Not in the kind of situation where you do not have the luxury of a careful pre-flight inspection. I knew that. I had written it into my FAA amendment filing in plain language. The record said so. What the record could not do was prevent the emergency from arriving before the contempt hearing. Earl Dunbar collapsed in his kitchen on the evening of February 11th, 2021. His wife, Norma, found him on the floor beside the stove. The same stove she had been standing at when her own heart had seized 12 years before, and she called 911 with the particular steadiness of a woman who had already lived through one version of this night. The dispatcher told her that ground units were 45 minutes out on icy roads, the same February arithmetic that had sent her to a Lubbock trauma center in 2009. The same ice, the same distances, the same calculation that makes aviation infrastructure in this county something other than a luxury. A Medevac helicopter had been dispatched from the regional hospital in Lubbock. Estimated arrival, 22 minutes. I heard the rotors before anything else. That low, rhythmic percussion carries a long way on a still night in open country, and I was already moving toward the door when my phone rang. The Medevac crew had the coordinates for 7TX4 in their flight system, a registered FAA landing facility listed on the sectional charts, available for exactly this kind of use. They were 2 minutes out and requesting confirmation that the strip was clear and usable. I stood on my porch in the February dark and looked northeast. The yard lamp threw a pale cone of light across the near end of the airstrip, and at the far edge of that light, where the turf should have continued unbroken for another 620 feet toward the approach threshold, the asphalt the Aldridge crew had laid 4 months earlier caught the glow in a flat, dark rectangle. It did not look like a runway surface. It looked like what it was, a foreign material, uninvited, laid by people who had not considered what they were sealing over or what the consequences would be when someone needed the ground beneath it. I told the pilot what he needed to know. The strip had a solid asphalt obstruction on the northeast end, covering 620 feet of surface. The remaining usable length ran from the southwest threshold, compacted turf, wet from 2 days of freezing drizzle. I could not confirm it was safe for a night approach and landing by a loaded Medevac aircraft. The effective usable distance, accounting for the obstruction and the wet surface condition and the darkness, was not sufficient. He asked what the alternatives were. I told him the nearest confirmed clear surface was the county road to the east, if he could find a straight stretch long enough and free of overhead lines. I told him about the feed store parking lot in town, paved and flat, but with light poles on 2 sides that would require a careful approach. I told him what I knew in the order he needed to know it, and then I stopped talking so he could make his decision. The helicopter circled, once and then again. I stood on the porch and watched it, a moving light against the black sky, the navigation strobes blinking in a slow, patient rhythm, the rotor sound rising and falling as it banked in wide arcs over the plateau, the pilot reading the ground below him the way pilots read ground they cannot trust. I had made that same calculation from the other side, from inside the cockpit, reading a surface in low light and deciding whether it would hold. I knew what he was weighing. I knew what he was looking for and not finding. The helicopter did not land on 7TX4. It could not. The northeast threshold, the end from which a Medevac crew would normally approach into the prevailing southwest wind, was sealed under asphalt. The remaining turf was wet and shortened and unlit beyond the reach of my yard lamp. The pilot made the only decision available to him and set down on the county road a quarter-mile east of Earl's Gate, a long straight stretch with no overhead lines that he had spotted on his second pass. The paramedics reached Earl in time. He survived. He spent 11 days in the cardiac unit in Lubbock and came home in early March with a pacemaker and a new prescription and the same cracked passenger mirror on his green pickup he had never gotten around to replacing. He was alive. That was the fact that mattered, and I did not lose sight of it for a single moment in everything that followed. But the fact that he was alive was not a consequence of anything the people who destroyed that strip had done or considered or planned for. It was a consequence of a pilot's skill and a paramedic crew's speed and a quarter-mile of empty county road that happened to run straight and clear on a February night. The margin had been narrow in a way it did not need to be. The strip that could have received that helicopter in 22 minutes, cleanly and safely, the way it had received my Cessna and a veterinarian's Cessna and a crop duster's emergency landing and, 12 years earlier, Norma Dunbar herself. That strip had been made unavailable by a paving operation conducted in willful violation of a court order. Not by weather, not by equipment failure. By asphalt, laid without permission, on ground that had never belonged to the people who laid it. I wrote my statement at the kitchen table the morning of February 13th. Plain sentences, in the order that things had happened, without elaboration or emphasis, because the facts did not require either. A Medevac helicopter had been dispatched to a medical emergency in a remote area of Ridgecrest County. The nearest registered landing facility was 7TX4, identifier listed on current FAA sectional charts. The strip had been rendered unusable at its primary approach threshold by a paving operation conducted in violation of the standing permanent injunction issued September 9, 2019, by the 142nd District Court of Ridgecrest County. The helicopter had been unable to land. The patient had survived by other means. That was all I wrote. Gerald attached it to the contempt motion as Exhibit 14, alongside the 911 call log, the Medevac dispatch record, the pilot's incident report to the FAA, in which he noted that the registered landing facility at 7TX4 had been flagged in the amended FAA filing as compromised and had been unavailable due to a surface obstruction, and sworn statements from Thomas and from me. The contempt hearing was held in April. The asphalt on the northeast end had not softened through the February cold or the early spring warmth. It sat there through the rest of the winter and into March, dark and level and permanent looking, the way things look when done by people who did not expect to be held accountable. I walked past it every morning on my way to the equipment shed and looked at it the way I look at a document containing an error, not with anger, but with the attention of a person who knows the error will eventually be corrected and who is patient enough to wait for the correct process to do the correcting. The April hearing produced a finding of civil contempt against the HOA board, against Diane Colworth individually, and against Brent Aldridge and his company. The court found that the paving operation had been conducted in willful violation of the September 2019 permanent injunction, that the board's resolution had been a deliberate attempt to accomplish through a contractor what the court had prohibited the board from doing directly, and that the resulting damage had created a documented public safety consequence. The court's language was precise on this point, citing the FAA pilot incident report and the Medevac dispatch record by Exhibit Number 2 that the court took seriously. The contempt order required the HOA to fund complete restoration of the airstrip to its pre-October 2020 condition at a cost the court-appointed contractor estimated at $67,400. It imposed sanctions of $28,000 against the board jointly, with $9,500 assessed personally against Diane Colworth under a finding that she had directed the contractor engagement with knowledge of the injunction. Brent Aldridge's company faced a separate civil action that settled before trial for a sum Gerald advised me not to disclose publicly, but which covered the remainder of my legal costs with enough remaining to resurface the stock road on the south end of the property, which had needed attention for 2 years. The HOA membership held a special election in June of 2021. Diane Colworth did not stand for re-election. 3 of the 5 board members who had signed the paving resolution resigned before the election was held. The new board's first act was to send a letter to Gerald's office acknowledging the boundaries of the association's jurisdiction and confirming that the Mesa Pines, CC and Rs applied only to the lots depicted on the recorded subdivision plat. Gerald filed the letter with the county clerk as a recorded instrument. It sits now in the deed records of Ridgecrest County, indexed alongside Instrument 1983-00441. The deed my grandfather's estate filed in 1983, the one that had always said what it said. The restoration crew finished work on the airstrip in late August of 2021. I walked the surface the morning after they completed it, all 3,200 feet, from the southwest threshold to the northeast end, where the asphalt had been broken out and hauled away, and new turf had been seeded and tamped and was already beginning to show the first pale green against the caliche. The smell of fresh earth was there, faint and clean, underneath the dry heat of a late summer morning. The windsock turned in a light breeze off the plateau. I stood at the northeast threshold and looked southwest, the way a pilot looks before committing to a runway, reading the surface and the wind and the full length of the distance, and what I saw was exactly what I had built in 1997 and what I had filed with the FAA and what the court had ordered restored. 3,200 feet, clear, available. The same tool it had always been, ready for the next emergency whenever it came. The lesson I keep returning to is this: when an institution with apparent authority makes a claim against you, the first question is not how to comply. The first question is whether the claim has a legal foundation. In the deed, the plat, the easement, the statute, the governing document read in full, including the limiting language, the person citing it has chosen not to mention. The answer is always in the record. It was there before anyone wrote the first letter, before anyone hired the contractor, before anyone paved over a strip of ground they had no legal right to touch. The record does not change because someone with a clipboard and a rehearsed line of authority says it should. It holds. It has always held. And the consequences of ignoring it do not stay abstract. They arrive on a February night in the sound of rotors circling overhead, looking for a place to land that is no longer there. I went inside and made coffee. The windsock moved in the morning air, easy and unhurried, the way it has moved every morning for 27 years.